scene, 3, 2, 1, action. So welcome, Nathan. We are really excited to have you here talking to us about the legal and regulatory aspects of rating. Um, I have like a whole introduction prepared for you. But what really caught me, and I'd love for you to also introduce yourself uh, to the community. What really caught me is that you've been working in this space since 2017, uh,
Yeah.
in the understanding the legal and regulatory aspects of crypto, of DAOs, of how regulations are being framed. And we are really excited to have you here talk about that, since that's an area I feel that's still very murky, it's not very well understood in the fundamental rating aspect. So with that, kick it away. The stage is yours.
Yeah, thank you so much for the intro, Mayank, and thank you for all the people that connected me to you at Prime Racing. I love the work that you guys are doing. Um, I'm going to kick off with my presentation, if you don't mind. I'm just going to share that because I've got all of my intro stuff there. So you let me know once you can see my screen. There we go. So yeah, let's kick off with just a little bio on me. So my name's Nathan Vandy, as Mike introduced. I've got a background in a master's in European law, and it was actually during my master's that I looked at the data protection law implications of blockchain technology. Um, we won't go into that too much because it's not really covered by the prime rating. But yeah, that's where it all started for me, looking at data protection law. And then it's been a roller coaster since then. I'm currently a PhD candidate in blockchain governance at the Paris University in partnership with Harvard University. So doing some pretty cool and exciting stuff there. Um, I'm going to be doing like a lot of work on law and governance in the metaverse stack. So it's going to be really interesting. And my experience in Web3 is 4 years consulting as a legal and business advisor. So I've worked with the likes of Daimler, so FTSE 100 companies. I've worked with also the UK government. And currently I lead legal at Waseo, which is a legal and governance advisory boutique, and it's a non-profit association that supports mainly entity-less DAOs with their corporate structure, which is quite ideal because the main question for the Prime DAO rating actually is to do with corporate structure and how their corporate structure affects their trust levels. On the side, as you can see, I've got quite a colorful background. I'm not referring about the picture, I'm talking about my hobbies. I'm actually a music artist and producer, play the piano, and upload songs to Spotify. I won't dox myself yet. Like I'm an avid runner. I love jogging, and I'm really into manga and comics. Like quite heavily nerd out over One Piece, Naruto, and your Marvels and DC. So that's just a little bit about me before we get into the context of law and regulation in crypto Web3. So for most of you here that are doing these ratings, I presume that you're not lawyers. I'm going to make that presumption. And I think it's important to understand that law is complicated. It's the rules that regulate how we interact with each other and how we interact with businesses. And the reason why it's so complicated in the crypto and Web3 space is because it is international by nature. So crypto is, especially ones built on public and permissionless protocols, they can be accessed by anyone in the world with internet access. And that obviously means that there's different geographies around the world and therefore different jurisdictions that have that can be applied to the protocol that is being utilized. This is quite difficult because also law is typically 2 steps behind technology. This is a feature, not a bug. It has to always be behind technology in a sense, and they are trying to change that with more standardization and focus on principles of law rather than actually regulating technologies themselves. But that typically how it is how law functions. And also there's a wide range of issues to consider. Obviously, we're going to be keeping it simple with this. I'm focusing more on corporate structure because corporate structure is the main legal area that enables you to identify either an individual or an entity to hold responsible and to hold accountable for breaches of law. But as I said, I started in data protection. I've really focused a lot on financial law as well. So understanding securities law, especially when it comes to investing from VC DAOs to just VCs in general in the space. And but underpinning all of these is corporate structure. Like, it doesn't matter which area of the law you're dealing with, whether it's tax, whether it's IP, you will always need to understand corporate structure. So it really makes sense to focus on understanding the corporate structure. And then, as I've been speaking to Prime Rated, it would be good to develop more areas of law and even iterate how it's phrased. But for now, understanding corporate structure, so being able to identify an entity or company, is the issue to focus on. Law can often be conflicting as well. Sadly, this is even the case when it comes to corporate structure as well. There are some jurisdictions that really don't allow DAOs and protocols to have a legal entity to represent them, which is why you see a lot of DAOs moving or protocols moving to offshore jurisdictions. So yeah, that can be that can be something to consider. But there is a global move towards standardization of laws and regulations. So we're seeing that with the FATF, the FATF, the Financial Action Task Force, which is creating harmonization in financial regulations that affect compliance when it comes to financial transactions. So this is in regards to KYC and AML, and also understanding how it relates to protocols. So for example, they said that if a entity has over 25% of the tokens, the governing tokens of a protocol, then they would be considered to have to deal with certain AML and KYC obligations. And this is a law that will be implemented on an international scale. So it starts to give more reliability on the different standards that can be followed and the best practices that can be applied when setting up a protocol and also evaluating one too. There's still quite a few unanswered questions when it comes to, for example, DAOs in relation to corporate structure, such as the limited liability of DAO members, and is it the core DAO members that are going to have a limited liability, or is it members in general that are going to have a limited liability? NFTs with IP issues. We're seeing a lot of that happening recently. There was a case with Meta Birkins where NFT creator made a Meta Birkin collection, and this basically was infringing Birkin's intellectual property rights. And those issues are just starting to come up because I do believe in the future Prime DAO will probably start also rating NFT projects, not just DeFi projects. And there's also a lot of questions to answer in the metaverse space as well, when it comes to identity, when it comes to data protection, and so forth. That's even before you get to MetaFi. But this is just to give a context of some of the issues that are still in crypto Web3 that still have to be dealt with. But I really like the Prime DAO's process because they've kept it super simple. They know that it's going to take time to develop a strong understanding of these legal issues, especially for people that don't have a legal background. And therefore, you're not expected to be a lawyer or a judge when you're dealing with these ratings, but you're more expected to be an investigator. And I really like that. Of course, I'm going to explain some things that can be done to improve your investigation, and two, your explanation of the context behind the findings you have in your investigation. But I'm not expecting anyone to be quoting SEC regulations or FCA regulations anytime soon. So moving on to the regulatory section, this is going to just describe the extent and quality of the regulatory environment that affects the protocol. In a sense, it will explain the extent and quality of the regulatory environment that affects the protocol, but it's more that the extent and quality of the regulatory framework the protocol chooses to structure themselves into, because the regulatory environment is international, right? But the protocols will choose to posit themselves into a certain regulatory structure in order to best suit their business needs. And of course, that will help with functionality of what they're looking to do. Security as well, because especially with some regulations, you have to follow data protection, and legality too. So by us understanding the corporate structure of the protocol, we'll be able to follow up and look at all of the other different areas of law that they have to follow. So the first question is in regards to legal accountability. Does the protocol have any legal accountability? And I just wanted to pinpoint a few important things about this question. So first and foremost, just because a protocol has a legal entity, it doesn't necessarily mean that it's more trustworthy than one that doesn't. So you often have some big protocols that are developed by anonymous people that don't have any entities behind them. So I'm thinking of, for example, Olympus DAO. Like all of their developers are basically anonymous, but they still have developed a reputation over time to be untrustworthy. What this is focusing on is legal recourse. So in the event that a law is breached, and a dispute occurs, is it possible for the injured parties to be able to settle their disputes against the main or core members behind the protocol? And most protocols, especially ones that have people that are visible, and that have good lawyers, have created entities to ensure that if there are any disputes, if there are any legal issues, that their personal assets will not be affected. Instead, the assets of the legal entity will be affected. And this gives a route for people to be able to get legal accountability. I'm saying this mainly for context, so you understand what you're looking for and why you're looking for it when you're doing this question. And later in the tips, I'll give an additional point to this question as well that I think is important when you're looking and doing your investigation of the corporate structure of the protocol, or attached to the protocol. I think this will be really important. You'll see that later. But for now, as outlined, when you're looking for the legal entity, so the structure, corporate structure connected to the protocol, is there public information about this entity? Or is there limited information? Or is there no information? Or is there no legal entity at all? As you said, this isn't to really understand how trustworthy it is. It's about de-risking when you are investing into a project, to actually have someone that you can have recourse against. So the next question is about the quality of the legal jurisdiction. And to be honest, this is a question that is going to evolve over time as the law develops. And I had a really good conversation with Prime now regarding how this scoring system was set up with the different weights and what actually were the determining factors for putting the different jurisdictions in top tier, relevant jurisdictional applicable laws, or questionable or no jurisdiction. And the main point is a robustness of the law in relation to crypto. So a regulatory framework that does exist, even if sometimes it's conflicting or not even helpful for decentralized protocols, as long as it's robust or there's ability to get good recourse to the law and understand how to get that recourse. That's how it's structured. So you've got the USA, which is very, very clear how to get recourse. Australia, UK, these are mainly actually common law jurisdictions, and where most international legal disputes happen in New York and London. But then you've also got Germany and Switzerland as well, who have really developed strong crypto regulations when it comes, especially when it comes to custody, and Switzerland also when it comes to corporate structure as well. So you're going to have a lot of the best, I was going to say prime, the creme de la creme of the protocols actually establishing in these jurisdictions. But also in jurisdictions like Singapore and Estonia as well, where they've worked hard to actually develop frameworks. In Estonia, they even have a framework for allowing you to tokenize equity. So they're actually really ahead of the game too. And then you've got jurisdictions such as Russia and China who have laws, and they're not as robust, and they're definitely more conflicting when it comes to crypto. They change a lot. And then you have Cayman Island, who I think have actually a very clear law when it comes to crypto, and actually a good corporate structure framework. But when you're talking about trust, with quite a few investors, it's seen more lower down, even though there is a move towards more Cayman Island entities, such as ENS DAO. But this is really looking at how robust that framework is, and how it's being built up on. So let's move to some best practices. I went scouring through some of the answers that had already been done. And yeah, this was a pretty good one, in the sense that it actually gave context. As I said, I do assume that most of the raters that are working with Prime DAO don't have a legal background. So I'm not expecting quotation of laws, explanations of why the legal entity was good or not, and some of the thought process behind that, because that is what lawyers do. They're able to understand these corporate structures a little bit more deeply to give a better understanding of which would suit businesses in which settings. But here, this was a rating done on Nexus Mutual, by the way. Here, they've explained that the legal entity that was used allows Nexus Mutual to be able to KYC potential investors or members into the entity. And not a lot of protocols do this. Nexus Mutual is definitely a unique protocol in that sense. But it's explained the link between the legal entity and the fact that it allows it to KYC their members into the mutual. It's a limited by guarantee company that they use. And then also for the quality of the legal jurisdiction, this was good because, as I said, UK regulatory environment is well developed for insurance. So the UK legal framework has a long history of mutual funds. And mutual funds are where people are able to pool money mutually into a fund and then be able to decide how to use that. And for some of these poolings, they didn't just use it for investing into different projects and initiatives. They used it so that if there was an issue between any of the members, they would be able to get a portion of this fund. So it acts as an insurance. And that's the corporate structure that Nexus used. And as I said, I'm not expecting a paragraph, but it shows you that whoever did this, I believe it was Luke Dow, had an understanding of why the UK jurisdiction was used, even if it isn't too deep. And that helps give you context for actually giving the points. So yeah, that's why I put that under the bonus. Because typically most people, especially if you don't have any understanding, it does work to just give the jurisdiction, because in the back end, like Prime DAO will already look at the different jurisdictions which are more or less applicable for different entities, and enable you to, so they abstract that work for you in that sense. But it's good to have an awareness. It will also be good to include issues that the protocol might face in the future. So there are some certain jurisdictions which are changing their law and making it actually more difficult for protocols, or unclear for protocols. So we see that a lot with the UK right now. And when it comes to crypto custody and different things like that, they are actually ahead. But when it comes to giving clarity to DeFi protocols, they are not doing very well at all. And yeah, And then the last, but not least, and this is quite important, is explaining whether the protocol has an associated entity as a legal representative or a development studio as a service provider. So in the case of Nexus Mutual, they have a limited liability by guarantee representing the protocol. But then if you look at Uniswap Labs, they have a development studio, a service provider for the DAO. And this is very, 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 very important to have this distinction, because depending on which one it is, there's going to be different levels of liability that can be applied to them and different actions that they can take as well. So one of the main tips that I would say for this exercise is to look for policy documents. So go to websites, for example, and find their terms and condition, find their policy, their privacy policy. This is what I say to all my interns. Find all of their websites. And then when you go into their, for example, privacy policy, they will have the company that relates to that. That is the data controller, as we call it in Europe. I think it's different in the US. But the data controller is basically the company which is in charge of all the data protection issues. And there you can see what entity it is. You can do this in the terms and conditions often as well. But of course, you'll have some entities that don't have any of these legal documents. Also, I would encourage you to look at forum spaces and social spaces, and for example, use the search function and type legal, law, or incorporation, and you'll usually be able to find some information on the DAO and the different legal issues that they're facing, especially for the bigger ones that have realized that they need to take legal seriously. There's usually some discussion about it, and then you can get a better understanding of whether they have one, whether they're in the discussion of having one, or with some DAOs as well, whether they're dissolving them as well. So that happened more recently with MakerDAO last year, where they dissolved their Cayman Island entity and now have like a satellite of legal entities rather than just one. So I would encourage you to think very laterally when you're doing this. As I said, you're not necessarily a lawyer or a judge, you're more of an investigator. So with the first two tips, definitely use them. They're really good, but I'm sure you can come up with other ways of understanding the legal corporate structures of these protocols. I would just say that these are the first two that come to me, and they're really quick and easy, so you don't have to spend too much time on it. And I said before, learn from experienced raters and consult older reports, and then use the Gitbook page for helpful resources. Or you can even reach out to me. I'm available if you have any questions too. And that's about, yep. So typical mistakes is no context for scoring. I think that's really, really important to try and get some context of why they might have chosen to incorporate there. And then understanding that if the protocol has multiple entities, then you need to attempt to average out the score, because some protocols will have their legal representative in the Cayman Island, but then maybe have the development studio in Estonia, for example. So you'd have to average out the scores there. And then isolated analysis, because it's going to be really important that you actually understand how other protocols have structured themselves, so that you have a strong understanding of what is the best practices too. And then, yeah, try to use as many sources available. So their website, their Gitbook, Mediums, as I said, their Discord or their forums as well, so that you can get the best understanding possible. And that's about it. Hope I didn't go too long.
That was perfect. Thank you so much, Nathan. There's already a bunch of questions that are coming in on the chat.
Appreciate it, guys. I guess I'll go to the chat and then start from there. Voila. Okay, yeah, we have to win music. In due time, in due time. Is there any available stats about which jurisdictions are common or not in the ratings done to date? Which is the most important legal entity for analysis? There can be 5 or more. Exactly. So, as I said, Bob, the two main legal entity types that or the two main structures that you'll see are the more or less a foundation or association, or even limited liability by guarantee company representing the DAO. And then on the other side, you usually have a development studio or a service provider, which is doing most of the software development and then shipping it for the protocol to the DAO in that sense. Those are the two main ones that you need to understand. Of course, there can be others as well. So, for example, depending on the corporate structure that you want to set up, you can also have an entity which provides the employment services for the DAO too, outside of even the foundation or the association. But it really depends on the initiative itself that you're doing, because you can even outsource some of this corporate structuring, and that's what we do at Waseo too. But to answer your first question, it would be a good idea to look at which are the jurisdictions which are more common. I don't think that's possible right now. That could be another integration in Prime Rating where you can actually see which jurisdictions are each of them are doing. But from my practice, I've seen a lot in offshore jurisdictions. So, for example, when you look at API 3, who has one of like the best legal engineers in the game, Eric, like they set up in Cayman Island. ENS set up in Cayman Island. But then you have some such as LexDAO, which is actually a legal DAO shop, which I believe they set up in a US state. I can't remember the exact one. But yeah, it's not really, there's not a one size fits all with this. It really depends on risk appetite, whether you need a jurisdiction which is very well known for investors to smile at. Yeah, where your investors even are, and also the legal entity type that is necessary, whether you're going to have a representative of the DAO or like a software studio or development studio. I know I created more questions than answers there, but that's just to add a bit more color to that, because lawyers love saying it depends. If a project's entity is located in a country that is not mentioned as an example, how would you advise? That's a very, very, very good question. If that was the case, then I would definitely post it into the group where the raters discuss this, because it needs to be a decentralized and collective decision about which jurisdiction should be placed where. And I think eventually there'll just be a way to rate each jurisdiction, so it gets put into a certain bracket. But for now, I would definitely say it doesn't it makes a lot more sense to collectively decide where a jurisdiction would be rated rather than doing it alone. Interesting, Cryptic, Andy. Nice. Yeah, this is what I mean when I say that you can still have accountability in offshore jurisdictions. Um, I know that sometimes it doesn't look great optic wise, but I don't think a lot of protocols really care. They're looking for function rather than reputation, especially the bigger ones.
Nathan, for the recording, I would say read out loud the question.
I really like that idea, and this is an issue that I have: knowledge bias. So, legal entity plus KYC equals 15 full points. Could you think of any structure that could score even higher if that was possible? Amazing question. Legal entity plus KYC. The thing is, with this question, it's looking at legal accountability. So, are you able to actually find the individuals needed to be able to complete any legal dispute or find any legal recourse? So, legal entity plus KYC of all DAO members is the creme de la creme, because with a lot of these different corporate structures, you will have, as I said again, either the association or foundation representing DAO, and then the software development studio as well. And typically, the software development studio will be owned by the initiators, the founders, the core members. And with most associations and foundations, and this is why they're so special, you can actually have a class in their structure that just says DAO members, and it's a nameless class, so you don't need to mention anyone, which means that their accountability is actually a lot lower in comparison to obviously a legal entity where you've actually at least a software development studio where you've at least got some names, and then even further a legal entity with full KYC of all their members. But that's very rare, especially in public permissionless protocols. In public permissionless protocols, it's just impossible to KYC every single member. So it's usually for permissioned protocols. Well, a really good question again. What are thoughts of India in terms of regulatory clarity, and also UAE? So these are up and coming jurisdictions that a lot of people are actually going to start looking towards. India I think it was this year actually, they developed their tax regime and made it really easy for people to understand their tax obligations. I wish all the best with India being able to go through and implement that, because it's not going to be easy. But in terms of regulatory clarity, this definitely makes it a much more trustworthy jurisdiction for people to move forward to in general. And UAE is making it very easy for investors to set up shop, especially when it comes to crypto. So I know a few people that are definitely looking at UAE and doing legal audits there too. If a project in their privacy policy on website states that they are not responsible for the usage on a website, do you feel that would hold up on court? Right now, it depends on the protocol once again. Because at the end of the day, some websites are literally just UI for the protocol in the background, and they don't actually hold any personal data of the user, like at all. But then there are others where it's not just the UI, but they're also taking some of the data from their users as well, for what reasons, whether it's, for example, a DeFi game, right, where you have the protocol at the back and then you have the game at the front, and you want to keep certain levels of the players. and you don't want to do that on a smart contract side because it's too expensive. So you do it, so you abstract it to an AWS or an SQL database. And there, obviously, you have personal data, which is being used, and then it would hold up in court. So it really just depends on the technical infrastructure that is used. But once again, great questions. Are there any high-profile cases against crypto projects that you feel are good examples to learn from? Definitely so. So, as I said, there are a lot of crypto projects that have started implementing their frameworks in their corporate structure frameworks with a balance of more trusted jurisdictions and then more offshore jurisdictions such as ENS and API3. I think it might be helpful for me to even share API3's legal assessment that they did at the end of last year. Really, really, really great if you want to get a more deeper insight into the different types of corporate structures that are available. But yeah, it really depends because you've got those types of protocols, but then you can also look at your, let's say, XRPs, which have a much more elaborate and complicated corporate structure now. But initially, they started with just a developer studio as well. They started with like a software house company, and then it went from there for their corporate structure. And yeah, they set up in America and got a lot of heat for it, but they at least are able to be a flagship of how corporate structure can work, and also some of the perils on where you choose to set up affecting yeah, just how much it costs in the long term with legal issues. So you really got to choose your jurisdiction wisely. Cryptic Andy says, what's the legal standing and relationship between investors, dev studios, and the protocol? This is a super question which we as an industry are just understanding as it goes along. So when you say investors, I assume you mean like token holders of the protocol, because there's people that invest their capital and there's people that invest with contributions of their time and effort as well, and they are two different categories. DAO workers in a sense, and then token holders. And right now, there's actually a few jurisdictions that are developing specific legal frameworks for DAO workers. There's not too much that I can say further than that, but it's actually happening right now, which is really exciting in Europe. And when it comes to dev studios, they usually use this corporate structure framework in order to protect them. And that gives them a certain level of limited liability. So whenever I'm working with a client and they tell me they don't have an entity yet, that's basically the first thing that you do, because this gives you this individual protection even before you work out the entire protocol's corporate structure, right? But yeah, the relationship between them are still being developed right now. So for example, when it comes to KYC and financial compliance, this is typically, it depends on how decentralized they are. But for the ones that aren't decentralized, this responsibility is actually placed on the dev studios, so the core members initially. In America right now, in the US, Hester Pierce is developing this sandbox to allow dev studios and associations to have a 2 to 3 year period where they're able to build out their protocols without having so much regulatory scrutiny. But this hasn't been pushed through all the way yet. And also the EU is developing something very similar too. And in that association that I'm part of is doing a lot of great work with policy recommendations so that future generations of protocol builders will have a lot more regulatory clarity. So that's on its way. We're working on it. Thank you very much, Luke. Appreciate the invite as well. Bob, the assumption of in the rating guidance seems to be that recourse using off-chain measures is a good thing. I can understand that for business disputes and for lending, for example, take a DAO-only approach, though, is a choice for either counterparty to the relationship. How does that figure in the prime rating process? Really good question. With the DAO only process, it really depends on the level of real world interaction that the DAO has. So as soon as the DAO, especially if the DAO members want to remain anonymous, right? As soon as the DAO needs to start owning its Trello subscription or different AWS, different things like that. There are very few models that allow DAOs to be able to do that in an anonymous way. So, for example, there are prepaid cards. At Waseo, we're also doing a model where we de-risk the DAO. So we do a legal and regulatory audit on them. And then we leverage our non-profit association to represent them so that whenever they need to do anything, they can do it through the non-profit association. Even when it comes to setting up a bank account, that can be done as well. But they have to go through this audit and then also accept our governance policies to make sure that they follow the law. But when it comes to other models apart from that, it's very, very difficult if there's any real world interactions and you're doing a DAO only approach. I do agree that just because someone has a DAO only approach and doesn't have a legal entity, it doesn't necessarily mean that they deserve to have a low trust score, but that's not the point. The point is mainly about accountability and the ability to find people if there is an issue to take to court or settle beforehand, hopefully. And then prime rating says, all good, Bob. If there is nothing to find out about the legal entity or none exists, we usually don't rate them. Rating states, yeah, cool. Great. Yeah, so thank you for the call. It's really, really insightful. Shows that people have their ears to the ground. No worries, Pepe, appreciated. Yeah, and that's unless there's any all good, Cryptic Andy. Unless there's any other questions, that would be it from my side.
Great stuff. I was just giving some space to see if there's some more questions, but I think we tapped them all out. Thank you so much, Nathan. Thanks for all that wisdom and for sharing it.
My pleasure. My pleasure. Yeah, there's if you guys really want to get into some legal and regulatory alpha, I worked with INATBA, which is the International Network of Trusted Blockchain Associations. They're set up by the European Commission, and we did a 4-series report on everything law, regulation, and DAOs, DeFi, NFTs, and some policy recommendations for the European Union. So it's a bit of a long read, so it's going to be like a week of yeah, definitely. I'll send the link. It's going to be really great. They're slowly leaking it, so they leak like part of it every week. But I'll definitely send. They've done the DeFi one, they've done the DAO one. Next is going to be the NFT one, which touches the metaverse as well. And then last but not least, they're going to give policy recommendations. So I'll just post that here so that you can see the state of law and regulation in Europe, at least. Because yeah, Europe is doing some really great stuff. when it comes to giving legal clarity to space.
Nathan, could you also share your Twitter handle for folks who want to find you after this call?
Yeah, for sure. I'm not as active as I should be there, and I probably have some photos to delete from when I was like 12. But yeah, please do find me and don't judge. Appreciated. Keep it real.
Indeed, yeah, authentic. Yes. Alrighty. Thanks so much, Nathan.
My pleasure.
Thank you so much, Nathan. Going to stop the recording now.
Yeah, that'll be a good idea. Awesome.